A five-judge constitution bench of the Supreme Court is set to decide if same-sex marriages can be legal in India. How did this case reach here and what has the centre said so far in this case? I'll tell you in this video. Now, just to start with the latest on this case, on Monday, a bench led by Chief Justice of India, Justice D.Y. Chandrachud, has referred petitions to legally recognize same-sex marriages to a constitution bench of 5 judges of the Supreme Court. And the court will hear arguments in this case on 18th April. So for all of you who might be interested in the case, the hearing will be live streamed as well. So all of you can tune in. Now, a day before this, in an affidavit filed on Sunday, the centre vehemently opposed petitions filed by gay couples for recognition of same-sex marriages. The central government has said that same-sex marriage is against the Indian notion of marriage that involves a union between a biological man and a biological woman only. The affidavit says that living together as partners and having sexual relationships by same-sex individuals, which is decriminalized now, is not comparable with the Indian family unit concept of a husband, a wife and children. So the affidavit, of course, recognized that the Supreme Court in 2018 decriminalized Section 377 of the Indian Penal Code, which was a Victorian-era law that criminalized sex against the order of nature, which of course included physical relationship between same-sex couples. However, this latest affidavit by the central government claims that despite this 2018 judgment, the petitions cannot claim a fundamental right for same-sex marriage to be recognized under the laws of the country. How does it say so? It, among other things, essentially cited a paragraph from the 2018 judgment, which you can see on your screens right now. The 2018 judgment had said that an individual also has a right to a union under Article 21 of the Constitution, but it goes on to say that when we say union, we do not mean the union of marriage, though marriage is a union. So relying on a few lines like these, the centre government's affidavit has opposed these petitions. It said that the institution of marriage has a sanctity attached to it and in major parts of the country is regarded as a sacrament, a holy union and a sanskar, and this relationship essentially between a man and a woman is socially, culturally and legally ingrained. The centre has also rejected the petitioner's contention, and this was a major contention that came up in most of the petitions, that marriage is a private affair between two individuals, but the centre has now asserted that marriage cannot be in fact regarded as just a privacy issue between two adults, because marriage has several statutory and other consequences under various laws that flows from it. So it tries to say that giving legal recognition to same-sex marriages will give rise to a lot of complications in consequences, like I mentioned, in issues related to adoption, divorce, maintenance, inheritance, etc. All statutory provisions relating to these matters are based on a marriage between a man and a woman, and it is impossible to make these provisions workable in a same-sex marriage. This is the core of the contention of the central government. The 56-page affidavit says that the law in India describes marriage as a relationship between a biological man and a biological woman only. It gives examples saying that the Hindu Marriage Act and other family laws and penal laws at numerous places refer to opposite sexes as a husband and wife, male and female, bride and bridegroom, father and mother, minor and son, minor and daughter, him and her. So it goes on to say that in a same-sex marriage, it is neither possible nor feasible to term one as a husband and the other as a wife in the context of legislative scheme of these various laws. So it says that if same-sex marriages are allowed, several such provisions will become unworkable. The central government has also asserted that this is a matter that should be left for the legislature at the end of the day to decide and make a law on. This affidavit has been filed on at least 15 petitions being heard by the Supreme Court demanding recognition of same-sex marriages. For example, just to take you through a few of these petitions, one of the petitions has been filed by a Hyderabad-based couple, Supriyo Chakrabarti and Abhay Dang, who have been together for almost a decade. They had a commitment ceremony as well in Hyderabad when they exchanged rings and took vows. The marriage was in fact touted as the first wedding of gay men in Telangana at the time. In fact, you might have seen these videos and photos of them circulating around of the couple on social media at the time. Their petition in the Supreme Court now points out that despite this ceremony, they don't enjoy the rights of a married couple. They have therefore relied on the Supreme Court's judgment, 2018 judgment, and have highlighted the Supreme Court's emphasis on the right to marry a person of your choice. Another similar petition has been filed by another couple, Parth Feroz Mehrotra and Uday Raj, who have been together for the past 17 years, and they say that they've seen each other through life's ups and downs, sickness and health, through the best and through the worst. As per their petition, they are also raising 2 children together. However, they now claim that because they cannot legally solemnize their marriage, they also cannot have a legal relationship of parents and child with both their children. So they therefore assert, and I quote, if the petitioners as a same-sex couple enjoyed access to the civil institution of marriage, they would not face untold practical difficulties both vis-a-vis each other and their children. The denial of the fundamental right of marriage to persons like the petitioners is a complete violation of constitutional law, unquote. Now, all such petitions will be heard by a 5-judge bench, as I already told you. Just to let you know, the 3-judge bench which referred the petitions to a 5-judge bench invoked Article 145, subclause 3 of the Constitution to refer the case. What this article, this provision mandates is that cases involving substantial questions and interpretation of the Constitution should be heard by a bench of at least 5 judges. So, relying on this provision, on Monday, Chief Justice Chandrachud essentially said that the petitions, of course, invoke and involve seminal issues. He said that it involves an interplay between constitutional rights of liberty, life, dignity, equal treatment of members of the LGBTQ+ community, and specific statutory enactments which considers only a married union between a biological man and a woman, and therefore said that a 5-judge bench should be the one hearing it because it involves all these constitutional issues. That's all I have for you for now. Once this case is actually being heard in the Supreme Court from 18th April, of course, we've already told you that it will be live streamed, but we'll of course be tracking it, and we'll make sure that we'll give you all the updates related to this case depending on the hearings that happen in the Supreme Court. So do follow our YouTube channel and our website for more updates. Thank you for watching.